All right, everybody, we're going to get started. Welcome to Wired Justice. I'm John McCamus. I'm chair of the board of Legal Aid Ontario, and it's my pleasure to welcome you to this lovely setting and to this wonderful event. As David has already mentioned, this is a joint venture of Legal Aid Ontario, the Legal Services Society of British Columbia, and Osgoode Hall Law School. And I want to just mention in passing some of the people involved in those three bodies. From the point of view of Legal Aid Ontario, the person taking the picture at this very moment is Christian Justison, and he is an expert, our in-house expert on technology, introducing high tech into the kinds of topics we're going to be talking about over the next few days. And he's been instrumental in organizing this event, identifying speakers and so on. So Christian, many, many thanks for all the work you've put into this. Mark Benton is here from the Legal Services Society of British Columbia. The Legal Services Society is something of a leader in all of this in Canada. And we're going to be very interested to learn from Mark what it is they've been doing and their recent innovations. Osgoode Hall Law School, the Dean, Lawrence Sawson, has been very supportive of this. Trevor Farrow is going to be involved, another Osgoode colleague. But I want to focus attention for a moment on yet another Osgoode colleague. Fred Siemens by name. Fred is here. Fred and his wife Joyce Siemens, and Fred Siemens are a wonderful York University couple. Joyce was the Dean of the Fine Arts faculty and was a Professor Emeritus of Fine Arts. Fred joined the Osgoode Hall Law School faculty the same year I did. And I've known him ever since. I've known them both ever since, and it's one of the blessings of my life to have been a friend of Fred and Joyce Siemens. But more than that, I joined the faculty looking for a job out of graduate school. Fred joined the faculty to lead a successful practice with one of the large downtown firms. He was doing very nicely, but he had a vision that he wanted to start a community legal clinic at Osgoode Hall Law School. He became the founding director of Parkdale Community Legal Services. Parkdale was in turn the first community legal clinic in Ontario. Someone, when I gave a speech of this kind from BC, said, well, we were first in BC. Doesn't matter. If you were, that's great. But Fred was the first founder of a clinic in Ontario, and it led to the wonderful clinic system we have across this province at the present time. So Fred can be said to be and can claim to be not just the founder of Parkdale, but a very important founder of the clinic system and the wonderful poverty law system we have in Ontario. More than that, Fred's been very generous over the years organizing these kinds of events. There were a series of events of this kind. Mark Benton went to them all, I think, and remembers it well. Events bringing together academics with an interest in access to justice and poverty law, people from the legal aid world, and others with an interest in all of this for gab sessions, you might say, at Osgoode. Not terribly formal, rather informal sessions, in fact, and they were wonderful experiences for all of us. And this event is a direct descendant of all of that. Fred has been pressing us in recent years to reinvigorate this kind of process. We have, since the recession in 2008, been looking at ways to save money, not ways to spend money. So we resisted a bit, but Fred persisted, and I'm very glad he did. And ultimately, financial issues eased up a bit, and we were able to yield to Fred's friendly pressure. He made it irresistible by saying, I think I can get Roger Smith to come. So that just pushed it over the top. And here we are at Fred's instigation with another event of this kind, not too far from Fred and Joyce's cottage, as it happens. So Fred has been my colleague for all these many years. He's been a leader in the poverty law world. as a teacher, as a scholar. He's written lots about legal aid, organized legal aid conferences and publications coming out of them. Almost everything I know about access to justice I've learned in conversations with Fred. So I feel a very deep sense of indebtedness to Fred, not just for the CAB sessions, not just for today's conference, not just for all I learned from him, but for a life that he has devoted to access to justice. So thank you, Fred, so much. Well, I want to say a few things about our event. I've been coached in this, and I won't understand everything I'm now about to say. I think I know what this means. The entire room is mic'd. That means that everything you've been saying over the last 45 minutes has been recorded somewhere. And more importantly, people who are listening in on the internet can hear everything that's being said near any of the mics. This leads us to suggest that you should probably keep your thoughts to yourself while the speakers are speaking, so that the people off-site can properly hear what's being said. The point I really don't understand at all is as follows. Please make use, however, of the Wired Justice hashtag. One of the things I'm hoping to learn over the next 12 hours is what a hashtag might be. There's apparently a Wired Justice hashtag on Twitter, and you can communicate with us directly using a hashtag if you know what a hashtag is. Those of you who are off-site are able to look at it on screen, I gather. And if you're not happy with the particular view you have, it can be altered. I'm told you go down to the bottom right corner of the screen and you will find several options set out. We also are quite prepared, not myself of course, to provide technical assistance. And you'll find an indication on the Wired Justice website as to how that technical assistance can be accessed. What else can we say about what's going to happen over the next 2 days? We all know, however uninformed I am about such things, I do know that there are an increasing and growing number of modes of communication, technological communication, that are potentially of interest in our world of legal aid. And that it behooves us to learn as much as we can about them and how they might be employed so as to improve the quality of service we provide for our clients, improve the efficiency with which we do so. We can increase quality, not go crazy on spending new funds through the use of technology. It appears to be very promising indeed. Another point that can be made about all of this resonates with something Michael Trebilco said about legal aid some years ago now. Michael, looking at the legal aid system, said one of the problems in legal aid is that it provides service to a very small percentage of the population which does not carry a lot of political clout. It would be so much better, said he, if legal aid plans across the country could provide services to a much broader range of individuals in our society. Having had friendly contact with legal aid, those people who are also voters might be inclined to offer more moral and or political support for the funding of legal aid services. Well, again, technology provides the possibility of making available through the internet, through other devices, information, assistance of one sort or another, which can be made freely available virtually to everyone. So it creates a number of interesting possibilities for us, and it's wonderful to get together with a spectacular group of speakers and set ourselves the task of learning as much as we can and thinking creatively about how we might utilize these new technologies in our own work. We're especially pleased to have Roger join us. Roger is internationally known for his work in access to justice. He's developed quite an interest in technology and access to law, and he is one of our two keynote speakers. The other is former Attorney General Chris Bentley, who was the Attorney General when I first became chair of Legal Aid, so I got to know Chris through that and enjoyed working with him enormously. Chris is now at Ryerson University. He's head of an innovation legal technology project that he's heading, and he is our other keynote speaker, and I'm really waiting to hear what both of you have to say. As well, I have a list of the homes of the other speakers. They come to us from Ross Intelligence, from the Hague Institute for the Internationalization of Law, from Modria, from the Winkler Institute, from Alluvion Law, from Illinois Legal Aid, from Legal Aid Services of BC, of course, the Legal Services Corporation, the Center for Access to Justice Technology at ITT Chicago-Kent, and the Center for Computer Assisted Legal Instruction, and more. So it's quite an illustrious group, quite a sophisticated and experienced group from whom I'm sure we can learn a great deal. There are some topics lined up that I find kind of frightening, actually. Artificial intelligence, I'm not sure that's a good idea. But Christian reassures me that there are possibilities even there that have nothing to do with national security. I close by reminding you that the hashtag is up and running, so please communicate with us through that. And again, welcome to this wonderful event. We welcome you all. Look forward to this terrific discussion. David, to invite Roger Smith.
Thank you, John. Okay, there we go. Thank you very much, John. For those of you, I think everyone in the room knows me, but for those of you online, my name is David Mcclellan. I'm a Vice President at Legal Aid Ontario. Getting this conference underway was one of the tasks that I assigned to Christian, and I said I think he's done a spectacular job, and I'm sure over the next day and a half that you will agree with me as well. I'm very pleased to welcome our first keynote speaker, who, as John mentioned, is internationally renowned and has come all the way from the UK here to be with us at Wired Justice. Hashtag Wired Justice, if you didn't already hear that. Roger, again, as John mentioned, is an expert in domestic and international aspects of legal aid, human rights, and access to justice. He writes regularly in the specialized legal press in England and Wales, and has a regular op-ed piece in the Law Society Gazette and the New Law Journal. And where I see most of Roger's writing is that he edits the newsletter of the International Legal Aid Group, which I look forward to on a regular basis. And that covers international developments in legal aid, on which he has researched, written, and spoken widely, both at home and overseas. Roger is a visiting professor of law at the London South Bank University and is an honorary professor at the University of Kent. He is also a solicitor and has been director of the Legal Action Group, Justice, and West Hampstead Community Law Centre, as well as director of policy and legal education at the Law Society in London. And finally, solicitor to the Child Poverty Action Group. Roger is now working freelance as a researcher and writer. That's quite a resume. I used to have a paper route. So again, thank you for joining us here today, Roger, and providing us with your insights and information at Wired Justice. I turn it over to you. Thank you very much.
Thank you. Well, it's a...
I want to use this apparently. Thank you.
Can I just check volume? Can you hear me okay at the back? Well, it's a pleasure to speak at hashtag Wired Justice tonight. I have been coming to Canada regularly since, I think the first time was 1991. It's a quarter of a century ago. There are people in this room that I met on that occasion, at least 3. And I have in that time written up developments in 5 of your provinces, beginning and most recently ending with Quebec. And it's not only been work. I have stayed with the Zemans in the family island, which I think is around the corner there. I have taken friends canoeing in Algonquin. I have camped in BC's parks. I have taken an impressionable young daughter to see the Toronto Blue Jays, where she fell in love with a Mexican shortstop whose name I think was Alex Gonzalez or something like that. I have sketched out, but not yet finished, the definitive guide to coffee shops in Halifax. The best of which, should you need to know, in my opinion, as a mixture of ambience and flavour, is Steve Reno's. I really recommend that. And I've become a great fan of a country where, for me, as for Garrison Keillor in relation to Lake Wobegon, all the women are strong, all the men are good looking, and all the children are above average. It's my job to set the scene for the conference tomorrow. And I would agree with what John has just said. Christian has pulled together a superb list of speakers for you. They are exactly the people that I think you need to hear from, and that at the end of the day, you will have an understanding of developments in North America in particular, but also stretching into Europe, and I think it'll be a really good day. It will be crucially dependent on that man there, Carl, in charge of the technology. And I, like some others of you in this room, have organized in the past conferences which have depended on technology. They kept me awake at night. So if you get through tomorrow, as you should, without noticing the technology, then the man you need to give a real round of applause to is Carl, because it looks to me like he's going to do a good job, and you will get everybody. Mercifully, your two keynote speakers, no one wanted to take a chance on them, however good the technology, so Chris Bentley from Ryerson and I are here in person, and we'll do a song and dance act if the wired connection for #WiredJustice goes down. So my job is set the scene. That's made easier by the fact if you go on the website for #WiredJustice, the latest report that I have written on latest developments in this field, access to justice technology, is there, and you can read it. And it's not only me, it contains, Sherry has written a piece which is transferred from the website. I think other people here may have written pieces which I put into the summary. So if you want a coherent approach written down to the background, it's there and it's available for you. I should just explain that I have discovered late in life, I have been searching all my life for the ideal funder. The funder who would pay me by the day to write whatever I wanted on a topic in which I was really interested and which I thought was really important. And I have discovered this funder. Luckily, they're based in London. You haven't got a chance. Don't even think of it. They are the Legal Education Foundation, and they have funded me to write up developments. They've funded the website, Law, Tech, and Access A to J, and they fund the associated Twitter account. So that's the basis, and that's the basis on which I was speaking. Supplemented, doing a lot of work on Twitter, following up leads, and on some occasions travelling to see people and pick up what's going on. We should begin with a recognition that at a general level, our countries, and indeed the whole world, are in the grip of a revolution. This is a big picture before I focus down. A revolution likely to be every bit as profound as the industrial spurt that put my own country atop of the tree in the 19th century and led to the creation of modern Canada as one of its dominions. And like all revolutions, this has a dark and a bright side. Not everyone benefits from the platform or the gig economy and the Uberization of services. The impact of technology compounds the loss of steady and respected employment in mining, steel production, manufacturing, and it's a trend which manifests variously in different ways, some of which are very dark and are exampled by a Trump or by Brexit. These are affecting the political constitutions, political life of our countries. And quite a lot of people want to stop the world and get off. Go back to how it was, or how they think it was, with steady jobs, reliable pensions, ordered lives, settled communities, and let's face it, at least in my country, no immigration or less. But of course, that isn't going to happen. But it provides the backdrop to what's going on. And in legal aid, we need to be aware of the effects of these broader changes to society. Your potential clientele will change as the economy and the politics change. Many more people are going to come in and out of poverty. Some of the new poor will be much better educated and literate than those we have traditionally served in legal aid. Those left behind may feel more disengaged than ever. Physical communities may maintain less cohesion, and the legal problems of those on low incomes may change as casualisation transforms the labour market, and in countries like my own, private renting becomes the norm rather than public funding, changing therefore the problems which are presenting to legal aid. Government budgets all around the world are going to be affected by the speed with which you can transfer money out of jurisdictions, and you don't need me to say anything about the pressure on your legal aid budgets, which will just get worse. But one of the upsides of the current maelstrom of change is its energy, and you can't miss this. And Canadian legal services is as good a place as ever, are as good a place as ever as any to see it. BC has no less than 3 world-leading organisations in terms of the application of technology. Its own Ministry of Justice, it's developing the Civil Resolution Tribunal that I'm sure we'll talk about tomorrow, as the first online small claims court. The BC Legal Services Society with its Dutch influence My Law BC, which again we will hear about, and which I believe is a vision of the kind of interactive website that will sweep the board in terms of the field of legal information and advice. And, it's probably not here, the Justice Education Society, whose imaginative use, for example, of video avatars on its websites shows a future where the visual can be incorporated into the written in the communication of advice. I'm just going to stop there in the hope that someone would bring me a glass of water, which I'm going to need in a minute. And Ontario provides an interesting collaboration, which Chris will talk about, between a university and the Ministry of the Attorney General in a competition for legal startups. A good instance of a very modern combination between the academic, the political and the commercial. And you'll hear 2 tomorrow from Ross Intelligence, which is now based in, I think, San Diego, but now based in California, but began its life with students, I think, from the University of Toronto, and is taking a lead in the application of artificial intelligence, and particularly IBM's version of it, in the field of law. And in Quebec, you have a prize should go to Quebec for the best named institute in an academic context dealing with this field, which is the Cyber Justice Laboratory, the Laboratoire Cyberjustice, which I just think wins the title and is actually a very impressive organisation behind it. I want to use my time not so much for description and throwing tidbits around of what's going on, but to try and raise 2 subjects for debate and discussion. The first is to try and get an overview of change. How do we understand the drivers for change? How do we put together all these things that are going on? And the second is more specific. What should be the response of your response, to the challenge of technology from the position of legal aid administrations? How would we scope out what your role should be? And on these I claim no great expertise, but I have opinions, and that's always got me a long way in the past. There have been a number of attempts to summarise current developments. One of the best, which I commend to you, is recent, is the American Bar Association's Commission on the Future of Legal Services, which, if I remember rightly, between pages 19 and 31, gives a very detailed description of the trends which are happening in the States, and it's applicable to the UK. I'm sure it's applicable to Canada. One of its recommendations, which could prove to be important, has already been implemented, and that's a centre for innovation, which hopefully will become a source of thoughtful writing about what is going on. The only problem with the ABA analysis is that it doesn't group the new developments it doesn't group them together. So it lists them sort of one by one. And it may help to get, as I say, to get an understanding on current developments if we can see some ways of grouping them together, both in terms of technology and in the underlying currents which are using that technology. Out in the lead is the drive for profitability by the large corporate commercial firms. They led the way in the use of the cloud, case management systems, outsourcing, and the first wave of back office reform. They are leading the way in the deployment of artificial intelligence to process law itself and the big data that surround commercial transactions. The English commercial firm that I did my articles with, which is Allen & Overy, has no less than 2 partnerships with major AI developers and is looking to use big data and AI to bring down the cost of its services and improve its performance. I used to argue that AI is up there and not really relevant to legal aid, which will move around at a lower level. I actually think that's too crude, and that we will see some seepage down from AI. And the areas where that might happen will be particularly in relation to advocates, and of course we've got a specialist bar. You will have de facto specialist bars, and it may well be that advocates use AI to process law. It would be an obvious development in case precedent systems like our own. And there might also be areas like employment, where there are a range of potential users, poor and relatively rich, institutional, individual, where there might be the cash to develop AI. And of course, as AI develops, it will get cheaper. So I think it's too crude to say AI is up there and we're down there. But for the time being, I think we can say they're in a separate market. We can watch for interaction with it. Following the big commercial firms up in the big commercial world, we have the ones concerned to act for those on low incomes. Practitioners wish and need to minimize their overheads and therefore give themselves an edge on the competition. The hunt is on for what the future guru Richard Susskind has called the latent legal market. Those willing to pay a little and able to pay a little for legal services, but less than what currently would be regarded as the commercial rate. They would become clients if providers can get the costs down. Now, probably the best examples in the world of firms moving into this area come from my own jurisdiction, because the use of technology is combined with other regulatory reforms, which mean that we allow third-party ownership of firms. I don't think you do yet. And there has been an entry of venture capital into the legal market to bolster forms of provision which are national, web-based, and sometimes deploy aspects of unbundling. And for example, we have the establishment of an organization called Cooperative Legal Services, which is actually linked to the cooperative movement, which is largely a retail and wholesale operation. We have a New South Wales firm, Slater & Gordon, which has bought into the market in a somewhat similar way. There are financial issues about both of those examples, and some will say that the financial difficulties of those two firms indicate that the model doesn't work. But frankly, they are wrong. And there may be transitional issues with the first early adopters of this approach, but I think it will come through more strongly. And there are a variety of ways in which practitioners without major capital funding at all can base themselves on a virtual presence and deal with clients remotely, both in new organizational forms and old. It's possible to set up a website, use that as your main draw, communicate through Skype or its equivalent, and you could be based anywhere. You could run a practice in England from this island, or from the island out there. The technology cuts the geography, the proximity, the advantage of proximity. And there are various examples of doing that. There's a firm called Epoch, which sells services not to individual clients, but to legal services insurers, and it provides wills. And it does that on the basis of automatic document assembly, video connection with a small group of lawyers in the Midlands, and unbundling. So that's a new sort of business model. There are any number of ways in which firms are exploring, organizations are exploring using video. New Mexico Legal Assistance kept together its bankruptcy team by, when the money ran out, by keeping it in one place and using a video connection with other offices around New Mexico to feed clients through. Very simple, but actually pretty far-reaching in its potential effect. So those are two forces coming through from the profession itself. The third force is government, which I see in my text. I said its role is multifaceted. I think I was being terribly polite. It's got good sides and bad sides. The Ontario government is working with Ryerson and Chris to back legal innovation, and who could say a word against that? Good. Governments are more equivocal. We have and operate in different ways that have different impacts on legal services. We have a major drive to put our social security online, and that's fine. Well, it may be fine. But one of the problems that's coming up is when you start to use algorithms to determine how disabled somebody is, that actually there becomes a role for individual advocacy in relation to somebody, whether somebody is a 5-pointer, an 8-pointer, a 12-pointer, and so there becomes a real need, perhaps less need for take-up, and more need for advocacy at a specified point in the process. Our Ministry of Justice is also pushing ahead with small claims online. It is moving at breakneck speed to introduce an online small claims court. Personally, I said, watch BC. Let them fall on their face, make the commitment now, come in a couple of years later, you've seen all the mistakes that BC's made, and then clean up. But who listens to a commentator out on the outer fringes? Not governments, not my own. Our government is under massive pressure to make both income savings and capital savings. It wants to sell courts. It is selling courts like tomorrow. We'd like to band together as a commercial venture, as Legal Aid Plans of Canada, and buy a court in England for its potential real estate value. It would be a damn good investment. But the drive is there for online dispute resolution. Of course, that's been with us for some time and largely on a voluntary model. The difference which is coming down the tracks is it's going to be mandatory. That's going to be mandatory in BC, and it's going to be mandatory in England and Wales. We already know that. And the problem is that if you make it voluntary, both BC's government and our own has come to the conclusion that no one will use it. So you've got to make it mandatory to get the savings. But I'm not sure that we are yet at the point where it can be safely made mandatory, and there will be a whole spin-off of problems in relation to that. I have developed my own acronym, which I think is jolly handy to distinguish between ODR, online dispute resolution, which is perfectly acceptable and linked not only by its initials to ADR, but I have developed the acronym ODD, online dispute determination. So that's where a court is making a final decision online, and that's what governments like ours are doing, and there are going to be all sorts of spin-off problems from that need to be worked through, all sorts of difficulties, but it will also be a driver for online legal services and people servicing people going through those processes, and they'll be commercial if they're not public. With all this change going on, it would be surprising if some people in service delivery were not infused by the new technology and its possibilities. And I think you can almost put that through as a driver of its own. All around the world, providers are experimenting, quite rightly, with what can be done on the web. Some are digging themselves in holes, but others are out there wanting to be part of what is clearly an emerging world. A good example of that you're going to hear from tomorrow, Illinois Legal Aid Online, which has made a major step forward in terms of upgrading its online triage provision and its online capacity for automated dispute resolution. Our own Citizens Advice Bureau has revamped its material to make it more readable, but it hasn't gone to the interactive levels which I think My Law BC demonstrates. I mean, you have a world leader in My Law BC. I think it's brilliant. And once you see My Law BC, and what you should do if you haven't done it yet is just go online and check it out. It makes you realize how dated, it instantly outdates virtually every other legal advice or information site you have ever seen. But you still get websites which say, go to our online version of this booklet. And Gutenberg, good old Gutenberg, down there in Germany 600 years ago, he'd recognize the web. All it is take away the leather bindings and all that German type, and you stuck it up on a page, and you read it. And what the interactive movement, which originated with the Dutch Rechtwijzer and which My Law BC does, probably most widely in English, is show you the interactive capacities. And that understandably gets people excited, and I would expect that to lead on to a whole new level of innovation as people see what can be done and want to innovate it. And linked to that, and manifest in My Law BC, is automated document assembly. There's barely a legal transaction where at one point or another you don't have to produce a document. And automated document assembly, particularly when it's aided by visuals like Callie will talk about tomorrow, the A to J software, which is front-ending many of the court forms in the United States. There are real possibilities there, which people are going to want to take up. I'm going to leave legal aid administrators as a source of innovation for the moment, and just identify the last train, which I think is really interesting. And it's the drive of the entrepreneurs and the businesses themselves. Now, this is new in my experience. I've seen, hard-headed lawyers run businesses, get firms and build firms up from the bottom, but I have never before seen people with no real law background pushing to get innovation accepted, coming up with ideas for apps, for websites, and participating in a competitive environment which is based on the notion that actually most of them won't succeed. It's a gutsy environment. And your Canadian Bar Association had a pitch on the first day of its conference earlier last month. There's the Ryerson competition. We can see in England, just as an example, development of apps on homelessness, domestic violence. There's a law centre in Hackney, which is deprived. It's a gentrifying area of East London, but it has a lot of poor people in it still, running its own hackathon. We can see a move there among entrepreneurs to get involved in this business and to make money from it. And I think that's a really interesting new development, and it's aided by other things as well. Tomorrow you will hear from Modria, which is a company which is a spin-off from eBay, and PenPal, their dispute resolution software. They are out there selling, and you will hear from Moritz at the Hague Institute for the Internationalization of Law. I think they've changed their name now, but who developed the Rechtwijzer. And those guys, they have an institute in the Netherlands which developed the interactive website, and they are dependent on, they have no other money other than what they can squeeze out of Mark. For My Law BC, they've developed it in London as well, Relate, in a marriage guidance context, and they need to sell to keep themselves in business. So they are out there and they are selling. And you'll get the flavour of that tomorrow. Now, Let me come now to the role of legal aid administrations. You're going to know more about this than me. But there are just some things I want to say. First of all is you should appreciate that in Canada, you still have an independence of movement which has been taken away from us in the United Kingdom. We have moved to a situation where legal aid administration is managed within the Ministry of Justice. In my view, and for a variety of reasons, that is a disaster. We can go into that. But you still have a degree of freedom of movement, although I quite understand that most of your money is tied up in existing commitments you couldn't really change, and party to threaten. Well, how should you respond to all this swirling maelstrom of activity? And I have the following suggestions. First, you're in a unique position to chart what's going on in your jurisdiction in whatever form you think is appropriate and helpful for yourselves. Bar associations like the ABA and the law societies in England and Wales produce papers on future development, and they're fine and they're interesting and they're good. But a bar association or a law society has a fatal problem in that some of its members will benefit from the new technology and some of their members will not. And behind that is the notion, which they all know but the members don't want to hear, is that AI will decimate legal professions and probably, to bring it close to home to some of you, decimate law schools as well. The number, it will not be, as Richard Susskind had it famously in a book title, The End of Lawyers. But will be a reduction, I would have thought, in the number of lawyers, or certainly a change in the expectation of lawyers. And there are therefore conflicts within bar associations and law society, which it's difficult for them to deal with. And review doesn't have to be at provincial level. It shouldn't be in some ways. The law is jurisdiction based, so the law of Ontario is the law of Ontario, the law of England and Wales. The technology is international. And the interesting thing is how it reads across, how you can read from one jurisdiction to another. And you need to know, as legal aid administrations, what new needs are developing, where new solutions are emerging, and where new ideas are coming from that might be helpful in your context. In relation to the international, I hope that initiatives like the one that the Legal Education Foundation is funding will be helpful. Provincially, nationally, individually, that's for you to look at. The point is to watch developments and not make reports. There's no point in you repeating the ABA exercise. And if I was Mark or another CEO of a legal aid administration, I would just say to my director of policy, every quarter I want one side of A4 in two parts. Part one, significant developments that you've sniffed around the world that we might be able to snitch and use. And secondly, what repetitive tasks are our people doing which might be susceptible to mechanization, to technology in some fact? Just that sort of level of scanning seems to me really, really poor. And in that context, the move to do something, one has to be careful. Discretion can be the best part of valor. As I said, my own view about anybody, if you said to me, Rog, what should we do about installing ODR in the small claims system, I would say nothing for a couple of years. And there will be whole fields where early adopters take the risks. And governments won't listen and they will go too fast. And I would actually anticipate that we may well be in a period where there'll be some reaction, some backflow from innovation, as people say, it didn't work. And that just seems to be part of the normal sort of cycle of development. I wouldn't put too much weight on it. So one, I would scan developments in that kind of way. Two, you are uniquely placed to encourage the transformation of web-based services, particularly information and advice. You want to watch My Law BC like hawks. You want to squeeze out of them the analytics and see what's working and what's not. I think it's the future, but I could be wrong. Mark thinks it's the future and Sherry thinks it's the future. We think it's the future, and I think it's transformative. But we need to watch that like hawks. You are very close to it. It will be setting an expectation in Canada of what people will go to BC, see it, and you have to take a view for your jurisdiction on what you could do. But I would like nothing better to see it come into my jurisdiction. Just sent a word about there's a rather sterile standoff between technology hawks and doves. Can people use new technology or not? How many? In what way? My own view is that unaided, you can't really say that probably more than 50% of, however you define them, the poor, could use digital-only services. That is to say, 50% can't. And there are major policy implications from that. It means that it's behind my view that mandatory odd will fail. But that is not to say that some form of assistance with digital cannot increase the numbers of people who can successfully use digital mechanisms, and that's what we should be looking for. It's not often mentioned, but the origin of the My Law BC, the Dutch program, the Rechtwijzer, is backed up by a national network of offices all around. In every administrative area of the Netherlands has an office where you can go and get half an hour or an hour for free advice. And it's that kind of interaction between individual assistance and digital that we should be looking for to get us over the hump. And that takes me to a critical point about evaluation. There needs to be rigorous and publicly shared evaluation of innovative technology projects. You can contribute to that. There is a lovely piece of work from Victoria Legal Aid, which produced an app which was a complete dud. It was about the law of consent for young people. My children were only concerned about the law of consent. So if they had a question about the law of consent, it was where can you get false ID? But they distributed 1,100 copies of this app, and if it had been a booklet, that would have been it. Hey, we've got the app. We thought we'd sell more, but we got rid of 1,100. Well, actually, 1,000 people deleted the thing, and actually, the app didn't work because it was on an Android system that went out of date and they didn't update it. And anyway, when they looked behind it, actually, the app was misconceived. What did they find? Well, some old truths. They should have spent longer determining the purpose of the project before they put money into it. Well, who hasn't found that in any evaluation of a Dutch project? The old truths don't go away with the new technology. But all sorts of problems. But it's a really good example. VLAO really to be praised because a really good example in the public domain of, put themselves on the line and said we did a dud. And we can use that. We internationally can use that. And I hope that you will be as open with that. I see the Google Analytics on my website. It's frightening. If you don't put anything up for a couple of days, there's nobody there. It just fades. I'm putting gold dust. I am putting gold dust on there, and it's still timeless. But 2 days after it's up, no one's reading it. It's brutal what you get back from analytics, and we should be prepared to share that. And my next role emerges from the others. Legal aid funders need an overall strategy. You've got relatively little money. You need to scan what's going on, but you need to have some sort of context in which you're looking for potential innovation that provides both a framework for what you're doing and a benchmark for standards. And a good example of that is provided by the US Legal Services Corporation Technology Summit in 2013. This came up with 5 priorities for the Legal Services Corporation in relation to technology. Document assembly for self-represented clients, litigants, that would still stand. Better triage, the Illinois work is an example of that. Response to mobile technologies, I would have thought that's done. Since we can cross that off, everybody produces responsive design now. Expert systems, checklists, maybe unbundled services. I think if you look at that now, you'd say, well, where's the guided pathway? Where's the revolution to advice? And I think the putting of it down on paper and saying this is the strategy with which we're doing, within which we're working, is really helpful, because you can look back and say we achieved that, or that happened, and you can identify where you want to go and where the priorities are. And finally, legal aid administrations have to consider but not be overwhelmed by the downsides of digital. And we have to face up to these. There are difficulties in the use of technology for those on low incomes. We don't know the extent, and we argue about the extent of people's technological, cultural, intellectual capacities to use technology. Physical access to technology is not the problem. You can get on the web anywhere in England and Wales within 300 or 400 yards of where you are, unless you're in a major rural area. Just go to a library or a local authority. That's not the problem. It's people's capacity to use it when they're on. We don't know. No one really knows how well people have been adjusted to this. And what you can bet is it's a moving figure. Because as people have to submit their tax online, have to deal more with online transactions with government, so they will get easier with the use of technology. We don't know that, and we need to find out. There are a number of other things. Let me just cut something out here and just go to the end. There's another problem that needs to be whispered about in dark corners, which is it's harder to cut physical provision than it is to cut digital provision. We had, in Labour government, produced a wonderful web presence for the National Health Service. It was cut. It then had to be reinvented, but it was so necessary. It was cut in a way which you could not have cut a hospital. And there is a problem which we have to, I'm for defensible progress. And we have to recognize something which is quite difficult for politicians in particular, which is that progress can go up and down, and we have to make defensible progress. Which for me is another indication that we should be looking at digital linked with as a way of supplementing, getting more bang for our buck for physical provision, linked integrally to physical provision. But I don't want to end on a low note. I am excited about the possibilities, and the energy and the excitement of this moment in time reminds me of my youth and when I first met the people in this room that I know the longest, in the 70s. It was an exciting time for legal services. We were going to change the world, and well, maybe we didn't, but we had a lot of fun, and we made things better than they were before we came. And I think that's the hope for technology. Thank you.
Thank you very much, Roger, for those interesting and insightful comments, setting the stage for Wired Justice and what we're going to hear about tomorrow. And other thoughtful comments of my own might be that with how artificial intelligence is going to be impacting lawyers, I think I need to pay special attention to my pension statements. So thank you for that. Once again, for those of you who are just joining us online, my name is David Mcclellan. I'm from Legal Aid Ontario, and I'm here with Roger Smith, an expert in domestic and international aspects of legal aid and access to justice. We're now moving into an open discussion forum. I will be the moderator for that forum. I will kick off by asking Roger a question or two, and then we'll be welcoming questions from the floor as well as over Twitter using the hashtag WiredJustice. So, excuse me. So, Roger, if you're ready to go, I will ask you the first question. What the hell's going on with Brexit? You don't have to answer that question. That's fine.
Brexit is just a disaster. But I'm not going to answer that. Nor am I only going to answer questions. This is an audience that is above the mere question level.
and there are people in this audience who have things to say, which I think should be encouraged to put into the discussion and debate.
So comments, not just questions. Yes. All right, fair enough. Well, I am going to ask a question,
Okay.
Because I'm not that thoughtful. My question is, Roger, what would you say are some of the benefits and drawbacks to legal aid plans modernizing and trying to better embrace technology?
Well, I'm a lawyer, and I can answer that in a lawyer question. It would clearly be unthinkable that a legal aid administration did not embrace technology.
Well, clearly, I mean, to be more serious about it, I mean, clearly you do have to respond to technology. It's not you have to respond to technology, it's you have to respond to need. Technology may change the need, which is one of the things I've been trying to argue. And technology may allow you to get more bang for your buck in terms of what you're delivering. And you're under a duty to look at that. Your problem is you've got fixed budgets. And so any money that you want to put into technology is going to have to come from somewhere unless you can get an extra subvention from government. And that's where the difficult line is in terms of how you can free up money to make the necessary investment.
But BC did.
And we're going to be hearing much more about that tomorrow when Mark and Sherry present on MyLaw BC. As I said, if anyone in the room wants to get up and ask a question, the X marks the spot on the floor here where the cameras and the microphone will pick you up. And we have our first questioner ready to go, Jawad Kassab from Legal Aid Ontario. Jawad, what do you have for Roger?
So I just wanted to ask a little bit about some of the potential impacts on clients, and particularly clients. I deal primarily with refugees in the legal aid context. And so one of the struggles that we've had is looking at the basis of claim form, which is a standard form that contains a lot of, consistent data for every claim. So the name, what country of origin, what are your relatives, and so on and so forth. And so we spent a bit of money developing something on an A2J platform, and I'm not sure of all the, but it wasn't as successful as we would like it to have been. And there certainly was a lot of resistance in implementing it with staff. And so that was one of the challenges that we faced. I do think it was a great learning opportunity, and I think that we're ready now to move on to the next stage of what this technology can do for helping us with the basis of claim form. And I'm hoping that, potentially working with BC and looking at that opportunity, we're under enormous pressures in legal aid plans in Canada because of the enormous refugee pressures coming globally and the issues that we're dealing with. So I'm wondering whether you could comment on some of that, i.e. dealing with technology and persons from countries other than Canada, or other than, many from third world countries, many that are not speaking English and other languages and so on. How useful that really can be, and I think it can be quite useful. And any other comments that you have about our experience trying to use technology in that area?
Well, clearly in relation to refugee work, you have a really difficult client group. So you have a group who will be, will often have complicated stories to tell and have language difficulties and many other difficulties as well. So of all the audiences that you might be thinking of, I'd put refugees down as one of the hardest to reach groups. I think that if we just take the question more broadly, one of the products that I was really impressed by was developed by, this is not in the refugee field, it's developed by a family practitioner. And a guy who has a very ordinary firm down in Brighton, and he developed this product called Ciaro, which is, at its simplest, it's a form it's a guided pathway form, which the potential client fills in online and brings to, it's automatically sent to the firm. It's a little bit more complicated than that because the form then produces a dashboard for the lawyer in terms of what information has been given, what information is needed, and so it's sort of actually quite sophisticated in terms of how it prompts and how it shapes the case. Now, he's been able to reduce the initial, he reckons he reduces the initial interview time by about a third, if I remember rightly. So in terms of a general notion of using technology to help clients get it down, I can see, well, I have seen in the family field it working. I can absolutely see that in relation to refugees, they would be one of the, if I had a list of the groups I'd start with, I agree, I would begin for a variety of reasons with refugees somewhere down at the bottom. What technology does, I mean, if you have, technology does potentially help you in terms of languages, because you can, you potentially, instead of, I don't know how many languages you work in, but you can potentially use the same information used through a whole range of languages in a way that's harder face-to-face. But I would agree that refugees is a hard one. I'm glad you're optimistic that it could be used. B, this notion that you can use guided pathways and dashboards and things to reduce the time with a client, I think that's very fertile ground. And it's an illustration, I think the paragraph in here I took out, I think, that technology is not either or. It's not either, it's not face-to-face or digital. The best use of digital, it seems to me, is in some form of coordination with face-to-face.
Thank you for that question, and thank you, Roger. I have another question that I'd like to ask you. You talked about, a client group, refugees, and what a difficult client group they are to serve. As an administrator of a legal aid plan, I can tell you that the largest client base for our legal aid plan is young males who get in trouble with the criminal law. And so my question for you is, what do you think are the different, or what do you think is different about how people today expect services compared to what they would have expected 15 or 20 years ago?
I have no idea. I used to act for young males.
5 years of my life, I was a juvenile lawyer, a lawyer for juveniles. I doubt if it's changed much. It's a messy, difficult world in which a small amount of real criminality is mixed up with a lot of deviant behavior. I'm sure they're an audience. Well, interestingly, they're likely to be, they'll all have smartwatches and they'll all be highly wired.
And I think that's my question, is that it's obviously the underlying issues are the same. But young people today, you ask them to fill out a paper form to apply for legal aid services, they might look at you like you have three heads. If they can't, make web chat to access or ask questions about how to access a legal aid system, again, they might look at you strangely. They don't make phone calls. They don't necessarily visit in person. They want to access websites to get information. They want to use social media. So I would think as an audience, as a client base, that they are very much different than they were 15 or 20 years ago. They have very different expectations about how they're going to be supplied the service.
Well, that may be so generally, and then the question would be, and I think it can only be determined empirically and possibly by jurisdiction, it may differ, is to what actual use people in that group, young males facing criminal charges, what use they can actually make of the technology. There's some research which is actually done by actually done in relation to law students at the University College London, which is a reputable law school, highly reputable law school, which seemed to suggest that these first-year undergraduates hadn't got the slightest clue about how to use websites. We're looking up the law relating to matters in Australia and not distinguishing that between the UK and things like that. So I think there are questions about people's capacity to use digitally provided services in general. And I think the answer will be the different groups can do it differently, and it'll change over time. I would have thought that refugees is one difficult area. Young males facing young male defendants, I would guess, is another difficult area. I mean, I used to sometimes you'd have to go to their house and yank them into the court. And I doubt if that's changed.
You just send them a tweet now, and they'll.
Sure.
Once again, if anyone in the room has any questions, I encourage you to come up to the front. And again, you can take questions on #Wired Justice. Christian Justison from Legal Aid Ontario, you have a question?
You talked about the native app that VLA developed and didn't go so well. Do you have any examples of apps that legal aid programs or that are contributing positively to access to justice you could highlight as examples, or what sorts of things those apps accomplish that made them successful?
No, I'm tempted to say, whichever Chinese leader said, it's too early to tell about the French Revolution. I think there are some very interesting apps which are now being developed in relation to hope.
Apps, of course, is only one route. My Law BC isn't an app. I mean, you don't call it an app, it's a website. I think we've yet to see where the app is best used and how it would be best used. I think it was balmy for them to use it in the context they did, and they were right to hold their hands up to that. The notion of using it, I'm a cyclist, and Slater & Gordon, this New South Wales firm, has a contract with the Cycling Touring Club, which you have the app on your phone. It says it's CTC, it doesn't say about Slater & Gordon, and if you get hit on your bike, it then prompts you to take photographs, take witness statements, and I feel very strongly about that, because when I last got knocked off my back, I was too concussed to do any of these things. So I can see that's a very direct. What are you looking for in an app? You're looking for something where there's a real value in using the capacity of a smartphone, the GPS capacity, the immediacy of it, the photograph. So it'd be interesting to know if the domestic violence app, for instance, which has just been developed in the UK. The problem about it is, you're in an abusive relationship and your partner picks up your phone and, it says domestic violence on an app, or what happens then? But again, in terms of the notion as you record events as you go, that could work. An app which takes you through homelessness, I could see maybe that. I think that the field is open, and I think the field is really open.
All right, next question, Bronco.
About 20 years ago, there was an iteration of Star Trek that was called Star Trek Voyager, and one of the characters in that show was a hologram doctor. And at the time I saw it, I thought, well, that's really interesting, but that's way in the future. But now here we are in 2016. I'd like to hear from you in your travels. How far away do you think we are as a society from perhaps seeing something like that, for people to perhaps give triage of legal service to clients in that form?
Well, as someone who loves travelling, I just hope it ain't coming too soon, and the notion that I can be replaced by a hologram rather would be distressing. Justice Education Society get close to that, in that if you go on their sites which are about small claims, and there's another one, you get a picture of Jess, Justice Education Society. Jess is a woman. Works for Justice Education Society, and she talks to you. And she doesn't exactly come, she's not technically a hologram, but she's a video figure, and she's speaking to you. And I think the potential of that is, I'd be interested in what you think about that in BC, but the potential of that, I think, is fantastic, because you're talking about orally communicated information that's not written. You're talking about it being presented by a human figure, a face-to-face sort of image to person. And so I think maybe sometime before we actually get a hologram, I think the use of, and there's another point to that, because tomorrow we get a presentation on the A to J software. Now, I think the A to J software is based on a very simple notion of there's a visual line, a road goes to a court, And as you walk along the road, 5 questions come up, and you answer them, and you go, and it's fine, and it's visual. It doesn't half look old-fashioned. And I think good old Jess knocks that for 6. And there's an issue there that in a sense, it's pretty soon, if you're not a hologram or if you're not a video, you won't have the traction, because people understandably come to and this is an issue actually in relation to putting up web provision. People come to web provision with the expectations from the commercial market. And so when I was in law centres, you could get away with a pretty sketchy book on your rights on arrest or something, or at least we thought we could. I don't think you can get away with sub-commercial levels of performance on the web, because that's people's expectation of it. Holograms will come, but the use of video and the use of people talking to you, I think that's right. And that's the way we have to go. For instance, Illinois Legal Aid Online have some training videos for self-represented litigants. And they're static, and they're verbal. And Jess could do such a better job at that, talking to you, that I'm sure that one of the futures is video. And that's another frontier, to return to your space analogy. Thank you.
So Star Trek is upon us. Yes.
On the square.
Nye Thomas is stepping on the X. So Nye?
I'm from the Law Commission of Ontario, and a lot of what we talk about when we talk about technology is expanding or changing the way legal services are provided. What things like virtual small claims courts implicate at some point is the virtualization, or rather privatization, of dispute resolution. So, a virtual small claims court is still run by BC courts, still within the public realm. But once you expand technology, you allow people greater means of speaking to one another. You also raise the possibility of more private dispute resolution, arbitration, mediation, those sorts of things. Can you talk about that trend and what the implication, if it is a trend, what the implications of that might be for legal aid programs or civil justice generally?
Well, for civil justice generally, I think it's a real problem. I mean, the way it manifests for us is we are, at least for the moment, signed up to the European Convention on Human Rights, which requires, where it applies, for there to be certain provisions to hearing, one of which is public. So the question is, all these online stuff, how does it affect it? And that hasn't really been explored. I think the argument will be that in small claims it doesn't matter too much, and sort of de minimis rule. But once it gets beyond that, then the notion of the court as a public forum is really to be explored. Now, there might be ways around it. One of the really big advances, which is not terribly technologically exciting for us, is that our Supreme Court is videoed. So you can get it in real time and you can get it in non-real time, just as you can listen to us on #WireJustice. But it would be a small step beyond that to have a physical hearing, a partial physical hearing, where people were videoing in, where anybody could get access to the central sort of video, but not all of the players were physically present in the same place. So there might be some ways in which you can accommodate that. But the ODR and ODD groupings rather skip over the necessity for justice to be seen to be done. And as I say, I think that's probably all right. I mean, I think it's to be logged. I think you're absolutely right. I think if small claims really mean small claims, and if they really mean small claims being dealt with by a procedure by consent, then I think the problems are overcomeable. But as it stretches through the system, I think and there will be other aspects to it too. I mean, it's particularly important in criminal cases, where here, as I guess back home, increasingly defendants may appearances by video because they're in prison for preliminary matters, well, that's okay. But if that starts stretching into the trial, then there is an issue about public justice. I think that's right. To be explored. Is the answer.
So next question, Vicky Moret at Legal Aid Ontario.
Hi. I can tell you how excited I am by these types of developments. And sometimes I wonder whether it's going to take a major and almost holistic reform of our administration of justice. I mean, lawyers are steeped in tradition. We like our paper, and when I think about digital files and how efficient, filing and retrieving, and when I think about the amount of space that paper occupies and the number of lost files in courts, I think of all of the potential that digitalization will have in our future in the courts. But for me, I also worry about that whole change management component of it, is how do you move the profession forward? And maybe it takes a large, court administration reform to get everybody on the bus and moving forward.
Well, I think that's interesting. I think that the commercial forces, what I can see, it may be different for different jurisdictions, but what I can see in England and Wales is the commercial forces are driving it. And the big city firms are driving their way into high-end technological, and they've been through the outsourcing, they've been all the rest of it. The problem for the profession is the losers who are attacked. You can begin to say it's the losers who are attached to that. That's a bit unfair. It's probably the commercial losers, not them. But with the drive, that's why I put it in the way I did. I think the drive at the top end from the big city commercial firms is there and sets a standard for an expectation for the profession. I think, as I say, particularly in the UK where we've loosened our regulation, England, Wales, you can see big providers moving in and big money moving in, trying to that will revolutionize that. I mean, I can remember back in the day, I remember research saying that the major determinant of a successful practice for legal aid was proximity to a bus stop. Well, you wouldn't say that anymore, and you can begin to say the major determinant of a low-income practice is a good website and an efficient management system behind it. So I think quite a lot of the work will be done by the profession itself, and there will be a sorting out. And that is why I think that the ABA and the Law Society have some problems, because their members have conflicting interests. Because there are some killers in the legal profession. There are some hungry lions out there in the profession, and there are some timid sheep. And between a timid sheep and a hungry lion, there is only one result. It's just a question of time. So I think those sort of forces will move, and particularly where other things help them to. Governments will move to putting services online because they want the achievement, and that again will be a spur. So I was going to say I'm optimistic about change, but that takes a view about the change being good. But I think it will happen, and the forces will be commercial and governmental, and the legal profession is going to change in 10 years, and they all know that.
Next question, Sabrina Delhan, the Law Society of Upper Canada.
From the Access to Justice group. So we've talked today about how technology is really at its best when there's that human component involved. So when we think about people who don't have access to the internet, the digital divide, rural communities, refugees, the immigrant population, do you think the real innovative area is maybe in people who can translate technology rather than the actual act or individual item itself?
I just think it's going to be everywhere. I mean, if you mean translate, you mean that it'll be the lawyers using the technology rather than the clients using the technology?
Well, a lawyer or a librarian?
Yeah,
or anyone
an intermediary.
You need to know. Yeah.
Will intermediaries be used? Yes. Is there already evidence that people use trusted intermediaries? Yes, there is. I studies in the UK about how valuable that is in terms of people's existing use. I just think it's going to happen all over the place. And what I do think is that it's too early now to say this will work and that won't. And I do believe that for many things, the technology can work hand in hand with face-to-face. But hey, it actually occurs to me, I haven't got a will. And I've been meaning to make one for years. And I just need an automated will system. And I must also make a living will as well. I don't need a lawyer in relation to that. I'm quite happy I haven't got anything very sophisticated I want to do. So, do I need an interface with the lawyer? No, I don't. Do I need to pay a lawyer? It probably cost me $1,000 to get a will. No, I don't need that. So I think for some people, for some cases, we can do it on our own. And the question will be how many and what type of cases, because I think it will all be different.
Roger, we have a question that has come through on #WiredJustice. Christian's going to read the question.
You talked a little bit about the effects of artificial intelligence in the legal profession. And the question is, what should new lawyers facing the prospect of decimation by AI do? Or do you have any suggestions for how they can manage that in their practices?
Well, number one, become an expert in AI and be on the winning side. Number two, don't go to the city. Get yourself a nice legal aid contract, because that'll be the last outpost to... number three, reconcile yourself to the change which will come. I mean, I am not a pessimist in relation to the legal profession. I think law gives you a good training in managing in modern society, managing for others. So there will be a range of roles that lawyers can do. They will change, and the traditional career expectation. Now, I joined Allen & Overy in 1973. The expectation was I would leave Allen & Overy 40 years later with a whole load of money, and that was it. I'd stay in the... My friends did. Large numbers of my people did. But my cohort did. That was the expectation. You went in, stayed, went. And then it became, at least in England, more usual for people to move between firms. Now I think you're going to have to reconcile. Law is not a protected zone. It's going to be like every other field of activity. And number one, get with the winners. Number two, keep limber and flexible. And three, spot the opportunities and go for it.
Roger, this is Pierre Castonguay. He's the head of the Legal Aid Plan in New Brunswick.
Hi, Roger. Good evening. My question's a little bit more about human behavior. Often with legal aid clients, they tend to come to us at a very stressful time in their life, whether they're facing criminal charges for the first time or a few times, or whether they're looking at the loss of their own children. So this is a very stressful time for them. Our clients come and meet with our lawyers, and at times the lawyers tend to be as much counselors as they are lawyers. I'm just wondering, with the advance of technology, are we losing this human touch that our clients so desperately need from the lawyers at times?
Well, I would put it the other way around. I would say, how do we keep the human, given that that is true, how do we keep it? How do we keep the human touch? Which is, we're social animals, so getting a will is one thing. Dealing with what language you use, care proceedings, the language I would use. Somebody trying to take the kids away. Domestic abuse is another thing. And my whole line would be, we need to use technology where it can be used successfully, and we need to be on the lookout for where it can be used successfully. And we don't need to need it where it's no good. Don't use it. And so we've talked about hard to reach communities, constituencies. Refugees is one. Sort of people facing care proceedings, mental health, all those areas are going to be highly. There's going to be a problem. They are highly dependent a lot on human interaction, and you will be as legal aid people, you'll be funding them. They'll be taking up quite a lot of your budget, so that's going to decrease your flexibility. But in areas like employment, in areas like family, maybe in immigration, if not refugee, I think there are areas there where we can get more bang for our buck by deploying technology. But you have Richard Susskind who says here, and he'd say it's all going to go to technology. I wouldn't say that. I think there are whole areas where it's not appropriate.
Next question, Rogers from Heidi Mason, Legal Services Society, British Columbia.
My question is really a follow-up to Pierre's comment and into your comment of David McClellan about who's coming to us now. Young men, they don't trust lawyers. They would rather trust the tweet from their friend who told them what their legal solution to their problem might be than from a lawyer. Technology is a bridge to those clients who don't trust lawyers. Technology can be a bridge to those clients who have their own reasons or their own story as to why they don't trust lawyers. A marginalized Aboriginal woman who needs help with her problem may not go to a lawyer, but would go to a trusted intermediary who use technology to give them the information. I actually think technology is a solution to a trust issue that the bar has right now with the growing population. And another reason why the bar should be concerned about the growth of technology, because the public isn't trust.
I think that's a comment.
And I agree with that. I think
There is a whole, I've done
a certain amount of work in low-income countries, and the notion of using trusted intermediaries and using technology to bolster their capacities, paralegals of one kind or another, that's a fertile route, and I can't imagine that it couldn't work elsewhere in other areas as well.
All right. I think that basically brings us to the end of the Q&A part. So, Roger, thank you very, very much for your insightful comments and setting the stage for tomorrow. I just want to give you a little bit of an overview of tomorrow. So we will be starting up again at 8:30 a.m. Our first session will be our second keynote speaker, Chris Bentley, the Executive Director of Ryerson University's Legal Innovation Zone and former Attorney General of Ontario. Chris's keynote will be followed by a panel on computer-mediated education and its impact on legal education, featuring the Center for Computer-Assisted Legal Instructions, John Mayer, My Legal Briefcase, Monica Goyle, and Winkler Institute's Trevor Farrow. Then, following a short break, the Legal Services Corporation's David Bonebrake has a presentation for us, which I know we'll all find interesting. We'll continue on with Hills, Moritz Barendrecht, and from Modria's Colin Rule. Before a panel discussion about online legal forms and document assembly tools with Illinois Legal Aid Online's Christopher Alfano and the Center for Access to Justice and Technology's Jessica Frank. This will bring us to about 2 p.m. Eastern Daylight Savings Time. We're going to give you a short break at that point in time so you can kind of digest what has been provided to you up until that point in time before we get to our final 2 sessions of the day. Our penultimate session will be with Mark Benton and Sherry Mcclellan from the Legal Services Society, British Columbia, and Mark and Sherry will take us through their MyLaw BC tool, which we've already heard quite a bit about tonight. We'll be concluding with a panel on the somewhat scary artificial intelligence and deep thinking tools. So Neota Logic's Michael Mills and Matt Gillis and Andrew Aruda from Ross Intelligence. So remember to check out #WiredJustice for reflections on tonight's conversation. Please visit wiredjustice.com for more details on tomorrow's sessions and the speakers who are going to be involved. We'll see you back here at 8:30 a.m. And thank you very much, everyone, and have a great evening.
We're all done.